Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottled Business Sense show. Welcome back to the broadcast. I'm Rick Moscoso, one of your co-hosts this morning. Before I bring on Bill, just want to let everybody know and remind you that we have a great archive of past episodes on the Bottled Business Sense show, bottledbusinesssenseshow.com, where there's a whole host of episodes on marketing, video marketing, legal aspects of protecting your business and helping you run it efficiently. Bill and I have been doing this for quite a while now and love sharing our expertise with our listeners out there. If you're a first timer here to the show, welcome. We love doing what we do here, and we offer free advice to our listeners in regards to what I just mentioned about running your business efficiently, safely, legally, so you can go out there and do what you set out to do, and that is to be profitable, have fun at what you're doing, and make some money. So with that being said, reach out to us on email at bottlebusinesssenseshow@gmail.com if you have any requests for future episodes that we can talk about. And you can always find us on social media on Facebook, Twitter, and Google+. So with that, let me bring on Bill Bernard here on the other side. How are you doing today, Bill?
Yes, sir. I'm doing just fine this morning. And we have a show today that I think will continue in the asset protection mode that we left off with for the last show. And it's going to be talking about an issue that is very personal to a lot of people, but also kind of fringes upon the family law area. And I'm going to stop when we get to that area because I'm not a family law attorney, so I'm only going to talk about the asset protection portions of it. But that's all we really do need to talk about, because if you're going to get into the family law issue, then you're probably going to be involved in a whole lot of other things in the relationship that might go above and beyond the basic asset protection issues we're going to talk about today. So we're going to talk about cohabitation property rights for unmarried couples. Where you cohabitate, you're unmarried, what's your property rights? And I'm going to point out to everybody what you really need to do. Because when unmarried couples live together, Rick, for a while, they likely accumulate a good amount of property. It's in each person's best interest, therefore, to have done for them a cohabitation agreement, or other people call it a property rights agreement, that spells out who owns what and how the property will be distributed should the couple separate. Because you don't need a divorce if you're unmarried, obviously. And this is especially important where a couple acquires real estate together. It's not necessary where you've only lived together for a short period of time and you haven't accumulated any assets. But if you have, without an agreement, you could face expensive and time-consuming legal battles. I mean, this is the old story about going on the courthouse steps. The name calling starts, and here's what I'm entitled to. Here's what you're entitled to. And naturally, both people typically have different opinions as to what that is. So when is the best time to do this cohabitation property agreement, Rick? When would you say?
Boy, that's...
Think about the starry-eyed couple that meets, right? And when would you typically want to do this?
Well, if you're in that honeymoon phase, I'd do it right away.
There you go. I'm telling you, man, this guy is sharp. you do it when you're getting along, right? At the beginning of the relationship, like you would when you're going to get married and you do a prenuptial agreement, right? You do it at the beginning of the relationship when you're getting along, because this agreement is about you and your partner and what specific needs you both have with regard to the relationship. So what do most of these agreements contain? Let's go through a couple of things that probably you'll need to know. How are the specific assets owned? We'll get a little more into that in a minute. Whether or not and how income and expenses are going to be shared when you're living together. How newly acquired assets will be owned. Not only the assets you're coming into the relationship with, but now that you're living together, if you acquire new ones, how are they going to be taken title to? How bank accounts, credit cards, insurance policies are going to be managed. And how specific assets will be distributed in the event of separation. And what dispute resolution mechanisms will you have in place? In other words, we're going to have a binding arbitration, or we're going to have a binding mediation. We're going to let a third party decide these issues if we can't decide them ourselves, because we don't want to go through the expense of a long-term litigation, right? So these are all important factors that you're going to want to include. And I think I've named specifically 5 of these, 5 major factors that you're going to want to have in your property rights agreement, which you do while you're getting along. Now, how do you cover your house in a cohabitation property agreement? This touches on title and what we've just briefly mentioned a moment ago. When you buy a house together, it's a huge financial responsibility, right? And it includes a lot of different responsibilities. So here's what your contract should cover. How is ownership listed in the deed on the house? If you own a house as joint tenants with right of survivorship, when one of you dies, the other automatically inherits the house. So that's going to be in the agreement. Your assets will be decided in the agreement. But if you just simply take it in joint tenancy, that's going to make the decision for you. If someone dies, whether you're married or not married, the joint tenant's going to receive the house. If you own a house as a tenant in common, however, when one of you dies, that person's share of the house goes to whoever he or she names in a will or a trust. So you and I are tenants in common, Rick. When you die, you can leave your half of the house, or whatever percentage of the house you own, maybe less than half or more than half. You can leave that to your spouse or your children, and I get the other half, or the other portion, whatever the percentage left over is. If the deceased person does not have a will or a trust, his or her portion, I should say, of the house will go to blood relatives according to state law. That's intestate succession. That's where you go to probate court where you don't have a will, and you certainly don't have a trust. Now, how much of the house each partner owns, that should be decided. Additionally, you should know what portion of the home could be transferred. So if one of you owns less of the house than the other, but can acquire more by making mortgage payments, for example, that should be in the agreement. In other words, we own X house, and Rick, you own 30%, I own 80%, 70%. You can get up to 50%, however, if you make so many mortgage payments on the house by such and such a date. Okay, so that can be addressed in these cohabitation agreements. So you see how these agreements can get intricate depending. You should always sit down with a business plan and decide how you're going to do this, and then put it in the agreement. You don't write the agreement and then add to it later on. You can, of course, if something unusual comes up, but you want to have this established before you do the agreement. Mm-hmm. What about the issue of buyout rights? Usually people decide to have their original realtor appraise the house. Then they allow one partner no more than 5 years to pay the other partner for the home. Now, this can vary according to your specific needs, but you should have a way to allow for a buyout, because remember, we talked at the top about joint tenancy versus tenants in common. But what happens if neither of you die before you break up, but you're going to break up? Now you need to know what the buyout rights are. How are we going to work this? Who's going to buy who out? How much time do we have? What's the amount of cash involved? Well, it's going to have to be pursuant to an appraisal, right? You're going to want to have in that agreement that the property has to be appraised before you go ahead and decide how much money the person's going to pay to buy you out. So you have to have that contingency in there for an appraisal. To the house, if you break up, decide how the proceeds will be divided upon a sale, which we've just touched upon. But who's going to stay in the house if it's not sold? Right? You not only have to have a buyout plan, but then whoever buys the person out, do you get the right to stay in that house? Well, typically you would. If you're buying it out, buying the other person out, you would want to have rights to be able to stay in the house, right? Mm-hmm. Or if you don't talk about that, you may have to go through an eviction, a whole formal eviction process if you can't decide on this stuff. That's why you want to have this stuff in the agreement, because you don't want to have to pay money to go through an eviction process. Now we get into the little bit I talked about at the top of the show, which touches a little bit upon family law. And I'm only going to briefly discuss a little of this because I'm telling you this because it has to be in the agreement. Once it comes to fisticuffs, though, if you start fighting over this stuff, then you need to see a family lawyer. Many people use the term palimony to refer to support payments to an ex-partner when a couple was never married. Palimony is not a legal term. It carries no legal significance. In fact, members of unmarried couples have no legal right to support, technically, unless they have previously agreed to it. So to avoid a tense disagreement about palimony, it's in your best interest as a couple to include whether or not support will be paid should you break up. How do you cover that detail? You put it in the cohabitation agreement, right? Specifically, no support will be provided if we break up, or contrary, specifically support will be provided because you're going to your work and job and I'm taking care of the kids all day. You may have kids if you're unmarried. Recently, the California Supreme Court ruled that an ex-partner could sue for support if he or she could show that an implied contract existed between the two. In other words, that there was an understanding that I would take care of the kids, I would take care of the home, you would go to work, I'm entitled to some support as a result of that. So you want to be specific and cover that in the agreement, because creating a cohabitation property agreement while the relationship is sound can avoid a lot of tension and hassle and disagreement and heartache later on. And this becomes very important, right? When one person in the couple makes a lot more money than the other, right?
Right.
Let me be good, Rick, to give an example. Go ahead and ask your question. I'll give you a quick example.
I was going to throw a scenario out there, and we're talking about being protected from the get-go, but let's say we have a scenario where, let's say the husband or husband-to-be, the male, has just purchased a house a year prior to this relationship. Now they live together. They both share in the mortgage payments and funding of all the expenses of the house. They're together for 10 years, never put an agreement together, every intention of getting married somewhere down the road, but they've been together for 10 years, but everything's in the husband's name or the male's name, and then he dies. What happens?
Well, it was his separate property coming into the relationship, right?
Right. But she was helping funding and the mortgage and
she's going to have to retain a lawyer.
What happens in that case?
She's going to have to retain a lawyer and try to show that she's entitled to some understanding that there is an implied contract that we just spoke about that entitles her to some portion of that asset. It's a tough row to hoe, but it can be done. But why wouldn't you nip that problem in the bud by having specifically what the parties intended to by way of that agreement, right? Mm-hmm. That'd be the easiest way to take care of it. So let me give another example. Pat and Sam. Okay, I wrote this example down for a client some months back, so I'm going to read it. Pat and Sam are unmarried partners who decide to move in together. Pat is a successful surgeon, and Sam is unemployed. They use Pat's income to purchase a home that Sam will fix up. to protect their individual property rights, just in case they break up, they decide to enter into a written cohabitation property agreement. In the agreement, they decide that after Sam completes the home improvements according to the couple's plans, they will become joint tenants with the right of survivorship, right? They also agree that all furniture and fixtures that they place in the home will be owned and divided equally should they break up. The agreement explains that if the couple breaks up, that Sam would remain in the house to care for their child, but that Sam will compensate Pat for Pat's portion within 5 years. Aside from this house payment, no support or other payments will be exchanged between the couple. Now, there's a perfect way that covers a lot of the issues we've been talking about. And while it could get intricate and really court involved without this agreement, you can see how straightforward it is if you set this forth in a cohabitation agreement. Mm-hmm. So that was a mixture of a lot of different variables, and how simplistic it was made by setting it out in an agreement. Remember, scenarios can be totally different between two couples who cohabitate. That's why you've got to have this agreement, because one man's ceiling is another man's floor, right? You're going to have stuff set forth in your agreement that may not come even close to applying to another couple's situation.
Do you commonly see this in your business where people that are cohabitating will come to you for assistance in creating something like this?
I see it once in a while, because a lot of people don't understand that this is very asset protection involved, but they're becoming more in tune to that. A lot of people will simply go to a family lawyer to have this done, but then typically 9 times out of 10, the family lawyer will consult with an asset lawyer for purposes of formulating the agreement. So I say come to me or someone like me first, because everything we're putting in this agreement doesn't have to do with any family law rights per se, because the agreement is trying to dispose of any need for a family lawyer. But when people hear the word cohabitation, they associate it with divorce and sometimes go to a family lawyer first. A couple of other quick things before we end the show I want to touch on. Liability for debts. Remember, unmarried partners are not responsible for each other's debt unless they have a joint account or one is a co-signer or guarantor for the other. So any debts that are incurred, one partner is not responsible to the other. Would it hurt to put that in the agreement? Put a simple little paragraph in there saying that? Wouldn't hurt at all. Property rights of surviving cohabitating partner. Well, a surviving partner has no property rights to the deceased partner's individual property. The personal property, not the personal property, but the separate property that you mentioned in your example earlier, Rick, unless a partner leaves the property to the surviving spouse by will or trust, or unless you're a joint tenant. So I come into a cohabitation relationship. This property is mine, nobody else's. Barring any implied contract that the cohabitor can prove against me, that property will always remain mine, unless I leave it to my cohabitant by way of a will or a trust, or unless we decide to take the title to the property in joint tenancy, in which case when I die, it automatically goes to that cohabitant. So important things to keep in mind when you're cohabitating: how title is taken to the property. Is the property separate property coming into the relationship? If so, there's even more of a need for a cohabitation agreement. If you're going to accumulate assets while you're cohabitating, if you're going to have children while cohabitating, all of these things, buyout rights and dispute resolution remedies, all of these things need to be listed in a cohabitation agreement to make sure that there's a clear understanding of the parameters of the relationship. That's what you want in order to avoid court or excessive attorney's fees. And that's what we're here for, to help you protect your assets. And this goes, to your right to the heart of your personal assets. So you want to make sure you have these agreements in place if you're going to cohabitate with anybody. If you're going to live with a person and not marry that person, make sure you have a cohabitation agreement, much like you would probably have a prenuptial agreement if you were going to get married.
Right. Well, good advice.
And make sure you have another lawyer for your cohabitant review the agreement, so it can't be questioned, and you can't say that you strong-armed this person. Make sure you have another lawyer review it on his or her behalf, and then you're good to go.
Yeah. Well, it's all great advice. Just like anything else, be prepared. And in this case, if you are in a relationship where there's no immediate intention to get married, then this is a great way to protect both of you while you're in that honeymoon phase, and you're agreeable to just about everything in the relationship. So why not protect yourself as you go in?
You want to protect your assets, Rick. Boy, that's the name of the game. I mean, that's what we're here to tell people to do, because you're going to have a hard time business. If you don't go ahead and make sure you take all of the precautions that are necessary to protect yourself. So I hope everybody, understands that by now, because we've been doing this for a long time.
Excellent. Well, thanks for the information again, Bill. As always, great episode. Folks, if you find yourself in this situation or know somebody who's in this situation who is not knowledgeable of these rights, these property rights that they may have, please have them reach out to Bill, and be happy to connect with you and discuss your situation and see how we can help out. So, Bill, what's the best way to get hold of you?
Well, the phone numbers would be 949 area code. Both numbers. Personal cell is 413-6535. Business number 698-6222. Or email bill@wfblegalconsulting.com, and I'll be happy to help.
Awesome. Well, folks, we are only a couple weeks away from Christmas, and so I think that one of the best gifts that you can give to your spouse and to each other is while we're on the topic of talking about asset protection, Bill has a great product online that you can take a look at, and really a phenomenal deal when it comes to asset protection. And Bill, why don't you share a little bit of that information, the new website that we created for you?
Yeah, PYE365.com or protectyourestate365.com. You can get to the site by using either of those. Punching in either Protect Your Estate 365 or PYE 365. And it's meant to be for the family who needs to have a lawyer involved, shouldn't be doing the DIY stuff online for these exorbitantly cheap prices that don't give you the protection you need. And it's for $12.99. You get the living trust, you get the pour over wills, you get the healthcare directives, you get the power of attorney for assets and for healthcare. You get everything you need to set you up for life, and that's what the program was set up for. It's got tons of videos. It's got fact questions and short answers to everything you need to know or wanted to know about an estate planning program, and most of all, it's affordable. It's incomprehensible, really, that anybody else would be able to beat that price, if I do say so myself. So this is all professionally done. And you have access to me, unlike some of these programs online where once you do it, they input the information you give them and you never hear from them again. Yeah. So you can get more expensive and intricate trusts done for more money, of course, and you can access me through that site as well. But check out the site if you need a revocable trust for your family and you need all of the attendant documents that come with it. I think you'll be surprised. And if nothing else, you'll be well informed by just visiting the site and learning about all of those issues.
Yeah, folks, this is a great trust package, and I'll stress trust package because if you tend to be a DIY type of person and you go to these popular legal sites, you think you may be buying the whole package. You may just be buying one component of what Bill's offering in his complete offering. So take a look at the website, PYE365.com or protectyourestate365.com. Take a look at all the videos. They're a wealth of information. You might learn something from them, as I did, and hopefully you'll find yourself in a situation where you'll want to reach out to Bill, ask him more questions, or even participate in the program that he's offering. So again, thanks again, Bill, for the great episode.
Not at all.
Folks, you guys have a great and profitable week. I'm Rick Moscoso here on the Bottle Business Sense Show.